Hello, everyone, and thank you for joining us. This is the third of four panel discussions that we're having with several leading experts, faculty, board members, current and past from NACVA. We're joined today by Michael Kaplan, Hubert Klein, Mark Cusick, Laurie Maston, Greg Regan, and Zach Myers. They've been with us since last week, actually week before, when we started this series, developed to answer your technical questions to business valuation engagements and forensic accounting. This topic specifically for the next 2 hours, we're going to address ex ante, post ante, and defending your conclusions of value in court. As Chinda indicated, there is a Q&A dialog box that you should see within this Zoom window player. If you have a question for our panelists, please input your question into the Q&A box and we'll do our very best to answer them. We've had a lot of great participation up to now in the prior webinars, and we're hoping that you will engage with us as well. We've got these experts here to dive into the specifics and answer your questions. But before we do, I'd like to ask each of you a quick question. It's been a few weeks now since we've personally and health-wise been adjusting to COVID. Of course, professionally in our practice and our work life have been adjusting to it as well. What are some of the things that you've found to be helpful, either personally or professionally, to sort of help you balance through all this change? Michael?
Things that have helped me balance through the change. Well, I'm home most of the day, virtually all of the day. My wife is home. Fortunately, both of us are in professions where we can get most of our work done via Zoom or via reviewing files via the web, and it makes a huge difference. Another thing that helps me get through, and this is probably the biggest thing, is when I get a FaceTime call from any of my grandchildren.
Oh, yeah.
I mean, and that's what life is all about.
Yeah.
And I take it a day at a time, and I just count my blessing each day, my blessings, and I'm thankful that the good things are happening. And we will get through this.
Zach?
Spending time with family helps take off some of the edge. This hasn't really changed a whole lot of my social routine because I've been social distancing for about 10 years now, working by myself and working from home. And so this is probably more similar to the summertime with the kids being home. But for the most part, this is, it's not been a huge adjustment, but I think just, not watching too much news and taking a break, doing some family stuff, I think that's always healthy, and I would highly suggest everyone do that.
Greg?
Well, I work from home most of the time anyway, so that has not been much of a change for me, except that my wife, who is my firm administrator, has been in Wyoming with her mom for about 7 weeks. I'm hoping she'll be back by the end of the month to get back to a little bit of normalcy. But I think just managing for me has been just being careful to avoid the fear and the panic that seems to be so rampant in the news and in a lot of people's lives. Just trying to stay calm and not make personal decisions or business decisions based in fear.
Oh, that's great advice. Hubert?
A lot of what everyone else said. The other thing that I've done is I'm focusing on things that I've always wanted to do, but I've always prioritized into the bottom of the list. So now that I have this time, I have this list of things that I want to get accomplished. And now that instead of being constrained between, say, 8:30 and 6 o'clock at night in an office, well, if I get up early, I come down to the office in my house and I can get things done that I've just kind of let slide. And a lot of them focus on how to be more active in the marketing, how to stay in contact with attorneys, a good thing for everybody out there now. All the law journals, all by state, have all their super lawyers and all that other stuff. Now's a great time to send them a congratulatory message and engage them in a conversation. So that's what I've been using it for.
That's good advice. Laurie?
Yeah, so a lot of the things that everybody else has already mentioned are true for me as well. I do have to say I am very thankful and grateful for the level of technology that we have right now, because if this had happened 20 years ago even, I think, staying up to speed and kind of skipping a few strides and then moving forward, it would have been much more difficult. I've attended 2 weddings and a funeral via Zoom, which I never thought those words would come out of my mouth ever in my entire life. So, but at the same time, both parties in all of those events, they deserved a little bit better, but we did the best that we could. So,
Yeah.
Yep.
Mark.
It's been a time where I think we kind of take a look at all the different things that we've normally taken advantage of in the past. And now I think it's going to be a paradigm shift. I think people are going to look at what they've done, what they've learned over this period of time, and how can they do things a little bit better, right? Do they really need that office space that's that large? Has this really worked? It's kind of like a trial to see if in fact things are happening and people are productive. And maybe it changes a paradigm shift a little bit about what's coming in the future for a lot of people, which then ultimately changes margins and operating costs and all those other things across the board. I think people are going to be much more aware of what's going to happen in the future than they were in the past. I think that now people are going to pay attention more to some of the specific things like, where are we going? How are we going to get there? And maybe a little bit more attention that this could happen. I think it was a wake-up call.
Yeah, like you guys, I've been, I think, more focused on personal and professional goals and achieving them more than before. Not that I have more time. I feel like I have more time. I'm working probably more than I used to, but I feel the other time that I have, I'm able to really focus on achieving things that, kind of like you were saying, Hubert, you've been putting off for a while. It's been fun. It's been super fun also to Zoom with my family members. Last night we had a dinner. My nephew is a guitar player, and he gave us a concert, online. It was really cool to spend this time with our family, and we generally are close anyway, but are making time and connecting through these online tools, and it's been really helpful as well. Thank you all for sharing that. I think as important as it is for us to address these really technical topics, we're all in it together, figuring our way through it, and good input and feedback from you guys. So let's dive into our topic today. We've got some really good questions, and we'll start with this one. What are the panelists' views on handling damages cases in the pipeline prior to COVID, where you have already issued a report? And the person posing the question asks that you please speak specifically to revenue expectations, expense avoided cost issues, and discount rates. Laurie, you first.
I seem to be the sacrificial lamb. I can start the conversation and pass it on.
We're just being gentlemen.
So when we're thinking about anything that we already have in the pipeline, and specifically damages, lost profits, right? I think if you've already issued a report in the case is already, in progress, and you're just waiting for, the marking of time to, testify or give deposition, I think you have to have some considerations for the discussions you're having with the attorney and with the client possibly, but primarily with the attorney on what they want, how they want to handle things. So just broad thoughts are, if you have a report out there, you've already issued it, your attorney probably has a motivation that's different than your holistic motivation of just coming up with the answer. They are defending or presenting a claim for their client. And so they have a motivation maybe to either keep it the same, being that pre-COVID, maybe you have these opinions and it was a much bigger damages amount. Post-COVID, your opinions will change. And so plaintiff's counsel is not going to want you to probably change that. Flip side is true. Defense is probably going to want them all revised. So that's fairly straightforward. The question is really first, before we talk about those individual areas of how we handle the revenue, the expenses, all that. I think the first question really is it upon us to do the work, have a number in our head. We talk to a counsel, they say, we don't want a different number, but you get up on the stand and you give this huge number, pre-COVID number, and everybody says, well, what about COVID, right? So I've got some opinions on that, but I just want to frame that question because it's an awesome question. I just want to frame it up a little bit because I think we have professional considerations that we have to think about. We have considerations for the client and who's retained us. You know, at the end of the day, we really have our credibility that, my opinion is I have my own credibility that I need to, you know, assess. And my tendency or my, you know, my leaning on this is no matter what the attorney says, I'm probably going to be doing at least enough work to know ballpark how my number would change. And I think we can get into some of the details of, you know, where we are in the timeline of damages, et cetera. But I'll toss this over to Hubert first. And, you know, with that kind of a setup, and then, you know, Brian, maybe I can, you know, be cleanup at the end.
All right, so Laurie starts as a quarterback, and I guess I'm the fullback to plug the one hole here. But that being said, it raises a great issue. One, you know, revenue expectations. You know, if the report is out there, we're going to have to look at it. You know, I look at the scenario two ways. You can be the damages expert who has a report out there and the attorney tells you, go with it, this is what you're testifying to. And guess what? Cross-examination, you're going to ask the question, did you consider COVID? And if I say, no, I didn't, and why didn't you? Because the attorney told me not to, I've lost my credibility, right? Then I could do the alternative. I could have my report out there. I can do the alternative calculation, know what the number is. And then if I get asked that on direct or cross, I could say, yes, I've done it. And if they ask me, I could say, well, my rough estimate is Y. And then from there, you know, there can be a conversation with the court. We have a duty to our clients, even if the attorney retains us to keep the Covell process, you know, doesn't mean we're the attorney's hired gun. We're there to assist the trier of fact. Right. And there's a lot of wild card on the expenses and the revenues and all the other things that, you know, I want to be able to answer the question truthfully, also to save my client. Because if I say the attorney told me not to do it and here's my number, my client may be very upset because my client may not have heard that from the attorney. So that's one of the things I always look at. You know, you're better to be prepared because your reputation can be destroyed in one case.
Hubert, let me add something to that. I mean,
Go ahead.
you are right on, and Laurie is right on. One thing we have to realize, it's going to come out. If this case goes to trial, and we are on the plaintiff side of the case, and the attorney says, no, don't do anything with your report, don't do the COVID analysis, walk into the courtroom, you know that the issue is going to be brought up by opposing counsel. My take on it is you want to get out in front of it. You want to get out in front of it. And I would prefer, again, and all we sell is credibility. That's all we have to offer to our clients. My take is sit down with retaining counsel and say, how are we going to get in front of this during my direct testimony so that opposing counsel can't position it in a way that it's going to embarrass me?
Right.
Right. And as you said before, you know, one case, you'll lose all your credibility. And this is a time where we have a lot of those cases that could potentially do it.
Absolutely.
Yeah, and Michael, to add to that, so that's, do we do anything at all, right? And we really need to kind of dig down deep, but I think consensus is we probably do need to do something, yes. Right? But here's the second kind of rub of that is how do we look, you know, we can't ignore it. How do we look at a type of business or a type of, you know, contract that was breached or something like that, and then assess whether or not the business was already in decline separate from COVID-19 and that's just made it worse? Was it, you know, what was going on with it? Because, you know, we can certainly look to some industries that we know have been impacted, you know, pretty quickly. Anything related to, you know, travel, areas relating to where there's a high level of discretionary money that is spent for things like that, travel, hospitality. And those took a super fast dive, but those type of industries might actually take a pretty quick uptick once, you know, the social distancing kind of lightens. But if we look at to some other areas like fast food chains, Subway, Pizza Hut, Burger King, some of those chains, they were already in the decline you know, last fall before COVID. They were closing locations.
Yep.
So we can't, I think my biggest thought is I can't take the COVID hammer and use that as my only tool, because it's not all COVID's fault. It can't be the scapegoat for everything that you do, right?
We've got to be really careful to identify as much objective information as we possibly can about what were the trends in the industry, what were the trends in the specific business that we're looking at before COVID, and then what are those trends after COVID. I think we're really going to have to dig deep into research more than we ever have to be able to distinguish, you know, the whole issue in a damages claim is something happened and it caused a negative economic consequence.
Right.
So you have to tie the event to the consequence. And now we have another event. So you have to bifurcate the consequences between the two events and be really careful that you don't get, you know, in a corner, as Laurie was saying, and not consider the fact that you can't just lay everything on COVID.
Right. And if you want to wield the COVID hammer to try to justify lower numbers or greater than, I mean, we just have to go back through history. And Laurie brought that up earlier before we even started the conversation with everybody here as to the trends. We're relying on a lot of data. Don't forget history. History is important, right? History, if you forget it, it will repeat itself, but also it does repeat itself. I remember, you know, I was a child, but in the late 60s, there was a stock market crash. In the mid 70s, there was another blip with the stagflation and the inflation and the oil prices and all that, and the interest rates high. Then we go to the 80s. In 87, 88, there was another stock market blip. In the 90s, we had the go-go tech boom and all the dot-coms, and then there was a boom at the end, right? Fast forward to 2008. So hiccups, albeit, you know, this is a pandemic. It's totally different than a natural economic hiccup in the timeline. Happen. The question is, what is the recovery of those? And those are the things we're going to have to consider. And, you know, we looked at a timeline, and I think that'll be shared with everybody on here, but, you know, as a damages expert, you do have to look at that, because you have to make your own personal judgment and evaluation of the COVID impact on the cash flow stream you're looking at and how long you expect that to impact the business on a forward-looking model.
Sure. So we're making sure we're covering the three aspects of this question: revenue expectations, expenses avoided, and cost issues and discount rates. Do you want to kind of jump back into those three issues and sort of give your perspectives on those as we look to our next question? We got some really good ones coming in.
Yeah, revenue expectations, I look at it this way. You know, COVID-19 might just be a hammer and not a sledgehammer. It may be a sledgehammer, not a hammer. We don't know, but we have to make those judgment calls based on the best available information to us today. The same way with expense avoidance, because there may be things. We're on a Zoom webinar right now, okay, with hundreds of people. That's become commonplace. So the world may be going to where this is the way we're going to conduct a lot more business, which again may impact future forward-thinking expense structures of companies. And discount rates, you know, we still got to make our informed judgment. We have the historical data. And again, you know, we don't know how long this is going to last, so we can't pull out the sledgehammer on a discount rate.
You know, Hubert, one of the things I also think is important for us to understand from the revenue to the expense and then your risk associated to those is that it's going to be different for every type of industry and every type of company, right? And as you continue to go through it, you really need to assess each individual entity and determine how that's going to affect the revenues, how it's going to determine their risk. And you all start there from benchmarking the historical and finding out where was it that we were, what happened as a result of this event, and how much cost is it going to be, how much capital is going to be to get us back to, if even possible, where we were from a benchmark or even into growth. And those questions are different from every entity. If it's like, for example, if you're a hand sanitizer company, you're getting unbelievable margins on that product, and it's going to continue to go. But we all know that that only lasts for a certain period of time until the supply and demand curve evens up, right? If you're going to get those kinds of margins on that particular product, what happens? More people come into the market and produce that particular product, right? So the question is, how long are we going to retain those margins for what period of time until the market adjusts to the new normal or whatever that would be? And you have the same issue going on with the airline industry and you know, even the cruise line industry. How long before people decide they're going to go back into traveling where they're comfortable? How about the restaurant industry? How soon do they feel comfortable? Even if they opened up tomorrow, how long will it take for people to feel comfortable enough to say, I'm going to go back into that restaurant and still be comfortable with, I'm not going to get sick or a virus, right? Because that ultimately is the issue. So when you deal with
flip side, Mark, is what if the cruise lines or the restaurants, the price point drops? You know, that believe it or not, people are motivated by price, and sometimes don't even consider the health. How many people eat in a dive bar or dive place that they would never bring their spouse's significant other to?
Well, I'm not saying there's not motivating issues, right, to generate additional volume. But what does that do? It then ultimately changes your supply lines, right? Because you need to get that better. And if your supply lines change into half, then what happens to our margins, right?
Right.
We got to take a look at that. So everything's really connected, and you really need to understand not only the connectivity to your revenues and those projections and the ability to adjust your pricing and margins, because I think that's all going to come into this equation, right? But then the risk of being able to duplicate that.
Right.
I think one thing that we need to pay attention to as well is, where are we with the case itself? Because some cases have actual damages that have actually occurred in the past. And then, you know, so we can assess those because we have knowledge of what happened in the past and what harm, you know, occurred. But as we stand here today, what our analysis may have is some forward looking for future lost profits. And I think that's the biggest thing we need to focus on, because those past profits probably pretty good. Maybe the discount rates we might argue about, right? But it's that future forward-looking element. And what we're all bringing up, which I think is a good point, is whatever our forecasts that we had from, you know, maybe the plaintiff side were as it relates specifically to those saved costs, those avoided costs. I think we're going to have to be really much more diligent on, you know, what those are and moving forward, what those costs might be. You know, and it's really going to be kind of up to the, you know, individual analysts on, you know, how aggressive or how, you know, non-aggressive they are in that area. But I think the timeline can tell us that this might not be something that's just resolved in 2020.
Right.
And we're going to have to give a lot more thought. And Greg, I like where you're going on the industry research. Personally, what we're doing in my firm is we're pulling research reports that are at least 2 periods before the valuation date to look and see what's going on there, plus the one that's on the valuation date, so that we can really properly map some trends. Because some of that industry research information, when you get a, you know, one as of your valuation date, they're already, you know, looking forward and pulling some of that knowledge back into the research analysis. So we're trying to double.
That might be interesting for everybody to look at as well is the fact that at some point in time, if these were already in the works prior to the COVID coming into play, you've done some of that research already. And as Larry had brought up, some of that research may take into consideration that the industry was already falling, right? And now it'd be really neat to see, or at least take a look at what those forecasts look like before we thought about this virus, even with all those other issues that were coming in, and now how they would ultimately change and what that delta is going to be different between the two. Because I think we already started some of this work, right? You already went through all this without that piece. And now you're looking at it going, okay, well, now how does it change? And I think that'll help you understand the cause and effect of just the virus.
Yeah, and I think that it's really important that we pay attention to case-specific things and data. I mean, we are experts because of our ability to take data and infer some sort of expert opinion based upon that data. And even the relevance of past versus maybe post-COVID-19 data, that's going to be different on a case-by-case and company-by-company basis. So you have to be careful even not to overgeneralize by industry, because, you know, I have 2 valuations now, 2 restaurants, and one's doing great and one's not doing so great. And it very much depends on the very detailed analysis that you have to look at. I mean, you're not just forecasting widget revenue now, you're looking at how many widgets per month can you produce what's the demand, what's the supply, and who are your competitors, who's dropping off. And the prices are very relevant, but those are a function of supply and demand. So you have to pay attention to all of those things on a case-specific basis, even when it relates to business interruption claims. Business interruption claims, and specifically in litigation, you have different states that interpret the way you calculate or interpret the language in a contract differently. You know, everybody's familiar with the language within a contract, with how you forecast the pre-event revenue and or experience and post-event. So you have to pay attention to how, you know, the case law or the actual insurance contract is written, and how it would likely be interpreted with, you know, what you put relevance toward in your calculations. So you really got to pay a lot of attention to some details that maybe we weren't as diligent in the past with paying attention.
Well, even that we talked about cost avoidance, one of the other things, and one of the, it's in the chat, the Q&A somebody brought up too. Don't forget, some of this stuff isn't COVID related, right? We have this big oil thing going on right now where Russia and Saudis are fighting and driving down the price. Now, what if you have a business who relies heavily on energy consumption and usage, a manufacturing plant or something like that, that may have retooled and is doing something? You know, right now their energy cost is down. Chances are the economy starts accelerating again. Well, we all know energy prices, supply and demand go a lot quicker than the lag time on a lot of other things. So there are other things we need to consider as well.
I think given all the uncertainty that's out here that we're all talking about, I feel that it's more important than ever that we really understand and remind ourselves that we're supposed to be objective, unbiased experts focused on helping the trier of fact come to a proper decision. And there's always a tendency when we get hired by one side, we get to know them, there's a tendency to feel toward them. And I think it's just really important now to be aware of that and to do our best to kind of pull back on what our natural tendencies might be, and just be a lot more careful about the decisions that we're making.
Yeah, I'd like to add one more thing to Hubert's point on the economy with the oil, for example, and how complex this whole issue could be. You have a situation where the entire world demand went down as a result of everybody staying home in place because of the virus. So that's the demand side. And then you got the supply issue, and they just kept on pumping and pumping and pumping the amount of fuel. So it's getting hit from both sides. And then what you have to really understand is the cause and effect of that to the individual consumer, and how much money is that going to put back into the discretionary cash flows for part of this recovery, right? When everybody says go and we all start driving again, now gas prices are at $1.29 or you know, numbers that are conceivably less. Does that give people more cash in their pocket to get through some of those other things to help start this economy a little bit further? So everything is complex.
But look, in the United States alone, I don't know what West Texas crude is going for right now, but it's close to negative, right? That will put a lot of producers out of business, a lot of supply lines to the oil producers in the Oklahoma, Texas area. There's going to be damages models based on that. And was it all COVID-19? A lot of these places are remote or not a lot of people staff them. And how much of that was just a market collapsed on them?
Yeah.
Let's speak to the discount issue. The discounts and how that impacts the value and how you defend the discounts.
Well, the discount rate, Brian, meaning the actual risk associated with the benefit streams and the cash flows? Yeah, I think that when you can't necessarily quantify some of this numbers on how your benefit stream is going to be affected, then you have to deal with it in the denominator in your discount rate. And I think that's going to go up accordingly. And the less and less confidence you get in the projections or the capability of those projections, the more risk associated with those projections.
But you got to watch a double dip.
Yeah, one thing we have to be sensitive to, though, is are we looking at a lost profits analysis where we're thinking about, you know, risk tied with, you know, the product or service or whatever is, you know, the focus of the lost profits analysis? Or are we talking about, you know, when we're looking forward and we're looking at future lost profits and carrying that back? I think one of the biggest issues that whether it's a lost profits analysis or it's a valuation issue like Mark was bringing up is, you know, what do we use if we're going to make some assumption about borrowing rates? We're going to make some assumptions about what the safe rate of return is for those discounting those future lost profits back to the today. So getting out of the realm of what the profits are, what the safe costs are, but what's the appropriate level of risk with those future lost profits? Do we use 0 for a borrowing rate or 1% because maybe they participated in some of the federal funds?
Good point.
That's going to be a big issue as to how and who participated in some of those trillions, right? And ultimately, I mean, if you had, for example, companies that had payroll paid for and they still had people working at home and being productive, that's a different answer than if it was a manufacturing company. They had their payroll taken care of, but then they still didn't have the operating costs or their fixed costs taken care of. And as a result, they couldn't produce. So I think, there's a lot of different complexities into that whole issue, and also in determining how much is really economically lost.
Right. And you're going to have those businesses who took the money who didn't need it, going to have a problem justifying it. You got the conversion of a grant to a loan, and believe me, I believe there's going to be some litigation on that issue as well.
Yeah, sure. We have a question specifically. We have a client in buyout negotiations that operates fine dining restaurants. Obviously, the pandemic has drastically impacted the business. While our client wants to buy out the minority partner now, how are you communicating to your clients in moving forward with these negotiations? By the time the deal finally closes, we are hopeful operations will be closer to normal.
Well, I think that when you're looking at those situations where you have two individual parties and one wants to buy out the other, that's a negotiated amount, unless they have something in their operating agreement that says it's going to be a calculation and that's what the calculation is, or it's at some fair market value, which is uncertain. But there's a lot of times when you see something like that where one person believes that they're going to come back and continue to go on. Sometimes it's a negotiation, Brian, where we think the value is going to be here, but based on this, they'll take a smaller percentage to take something out of it, close it, and away they go. Right. So I think it's a negotiation at this point on who knows what risk is going to happen and how you're going to actually determine what they're willing to settle for. So if they want to buy out that minority shareholder, that's a different equation than if there's a minority interest that has to be dealt with versus a negotiation that they just want to buy out, I think. What do you guys think?
Well, I think we're going to cover that a little bit later on merger and acquisition activity and the litigation arising from pre-acquisition disputes. Believe me, there's a lot now. I was looking at the websites of various law firms. The Delaware court is jammed right now, and there's going to be a lot of post-acquisition. We're going to go over the nuance and terms. There's a lot of volatility in that marketplace right now. We'll get to that later on, but we'll have an answer for them, what's going on there.
Well, I think what's key on that question, though, is it sounds like existing owners are just buying out someone else. So it's not like we're trying to sell the business to a third party to go run.
Exactly.
So it's a completely different consideration when you have that internal activity going on.
Mm-hmm.
It may be just a matter of what do you have to give the guy to get rid of him?
Right.
Number one. And the other thing that I would say is just advise the client. Make sure the client is informed of the upside and downside because of the uncertainty. Yeah, there could be some real downside. The number could be way off, and there's uncertainty here.
Mm-hmm. Advice to the buyer: all cash deal, no earnout.
Yeah.
So for
also,
future, go ahead, Mark.
Also document it that this is a final deal. I mean, can you imagine you negotiate a deal and it's 20% on a dollar, and then 6 months from now we're right back to where we were, and he's knocking on the door again saying, "Where's the rest of my money?" Right? So those are some of your challenges.
Yeah, there may be a lot of those types of agreements where the door's left open. Sellers aren't willing to walk away and lose out in today's market. They feel it's going to come back, and they may negotiate that into the deal. So I think each deal is going to be unique.
And if the door isn't left open, the sellers are going to try to find a way to reopen it.
Then you have that argument if you actually took that as a discount when you sold it, it's because of the risk and the uncertainty, right? So you can make that argument that you got out when it was uncertain. We could have easily have went the other way and closed and never opened up. And then you'd be happy as you could be that you got something out of it, right? So to come back 6 months later after the risk is surpassed and then say, okay, I want to be back where I was. Well, isn't that easy for everybody to determine, right?
Or 6 months later, 3 locations are closed because they were
Exactly.
bad. If you're going to give a refund.
Yeah, right. Exactly.
Yeah, all of our crystal balls are broken.
Mhm.
Document it and make sure that everybody understands those insides so that if it does come back, you have some recourse.
So let's move to this question. How will the panelists be handling forecasts and future damages when the damaging event occurred prior to COVID-19? Deals where the client had already forecasted expectations. How about considerations of ex ante estimates that are based on forecasts, expectations that don't account for COVID?
Let me jump in on that. In a situation like this, I find it hard to embrace the concept of ex ante. We're living in a world, we're dealing with a world where we're trying to make the plaintiff whole, where we have a situation where the plaintiff's been damaged, wants to be made whole. The law provides for the plaintiff to be made whole. An ex ante calculation just doesn't do that. An ex ante measurement of damages. So if we've already done it, and if there's already been a calculation, if there's already an understanding of what the numbers would have been, when COVID-19 came onto the scene, that changed the whole world. We have to go back and revisit it. We have to go back and revisit it and be prepared to address the difference between what would have been and what actually happened. And the what would have been is going to be very, very different.
Well, it goes back to what we talked about on the valuation side, but it's more important, I believe, on the damage side. You have to link in causation and reasonable certainty.
Yep.
And on the X or the post, you have to look at the causation, because if you can't definitively say, even if the attorney tells you to assume liability, that the breaching but-for event is the entire cause of the damages. Because if it's not, you're going to look ridiculous and lose your credibility. It's that simple. You know you're going to get asked a question. You know you're going to consider it. And if the client gives you information and you don't ask them, well, how has COVID-19 impacted this, and what was going on beforehand? And did you have problems with any other vendors or customers before the breach? You need to ask all those questions and have the answers. Even if the report is done and you haven't gone to trial yet, you have to address those issues, because causation's a big one these days. And I know a lot of accountants, it's in the standards of various organizations and when you deal with causation, but the defense of the attorney told me to assume liability, so therefore everything related to my damages number is based on the breach. You know, that may work, but in a good courtroom with a very, very good judge and a good cross-examining attorney, you never want to admit that you're an ostrich.
No, establishing the causal link is critical. We as an expert have the duty to determine whether the evidence indicates that a causal link has been established between the alleged actions and the economic consequence. And if we don't do that, it's just not going to be a fun day.
If you can't connect the dots, all you have is a hypothetical.
Yes.
Correct. And there are other theories, you know, I teach a forensic accounting and damages course. And one of the things that comes up there, was it just an error? Sometimes, you know, is that a recoverable damage if two parties made a legitimate mistake and there's a period to cure? You know, was it negligence? Was it gross negligence that got you to the point in something? And that all evolves around the causation as well, you know. And if the business is on a decline, somebody breached a contract, that contract was going to be good for 3 years, and then COVID-19 hits, it's a big issue. And a lot of the cases I've been in, especially with supplier contracts, everybody forgets to read the contracts and thinks somebody breached. Those contracts are cancelable on 30 days notice. So is it reasonable to expect that if COVID-19 hit, somebody would have canceled the contract? Which is a causation effect.
Yeah.
Next question. I am valuing two businesses in a shareholder oppression court case. The judge has decided on a valuation date of May 13, 2018. The valuation date is long before COVID-19, but my report date will be after. My understanding is that COVID-19 is then a subsequent event and should at least be mentioned in the report. Is that correct?
Yes.
Yes.
In the standards, whether you're following the AICPA standards for business valuation or the NACVA standards for business valuation, allow for how you put those into your report. And the NACVA standards are not quite as direct and you know, telling you exactly where to put something. I hate to put it that way, but it does show up in the introduction section when you look at the report writing standards for NACVA, that you should identify subsequent events. Now the question becomes, since this is litigation and the report writing standards don't exist, do you still need to put something like that in there? I think if it's before the issuance of your report and it is a subsequent event that you have knowledge of, that the standards say you at least have the ability to put it in there. But I don't know, you know, I know that we've discussed this and had some arguments in the past couple of presentations on this.
Well, the reason for the litigation exemption is because you need a little bit of leeway as to what specifically to put into a report. But you need to focus on whatever's in your report. It needs to be helpful to the trier of fact based upon the user. You know, even if you put something in your report, it may not even be relevant to the judge at the end of the day. You know, you may want to veer on the side of conservatism and go ahead and put it in there and be safe. But I think you have to keep in mind, yes, there's a litigation exemption, but you have to make sure ultimately that your report is going to be usable. So if that date after the 2018 date that this question is specifically asking about, if a value after that date is not relevant, which it may not be, especially if you're needing to value something as of a date in 2018 and you're trying to determine whether or not that price was fair back then, yeah, you can go ahead and put a subsequent event disclosure in there if you want, but you have to make sure to be very, very specific as to what you mean by it. And that maybe it doesn't change the date as of 2018, but it does change the date if the judge were to say that the more appropriate date is later on. I think we have to be very, very clear as to what we are saying there, you know, because something being subsequent, you know, yes, it may be very material, but even the AICPA standards say that it's if the valuation is relevant or the value is needed after the date of the report or the date of the value. So you have to pay attention to what they're using that value as of that date for specifically.
Anybody looking for specific guidance as a CPA, AICPA member, they have an FAQ checklist which has that on there. But I think we were kind of in agreement that if you did a valuation and a report had not been issued, or even if a report had been issued, you know, if it hasn't been issued, the report, we would probably put the subsequent language somewhere in the report, subsequent event, because we'd feel that would be fair. If the report has been issued, we all probably would at least do some sort of calculation and be prepared to answer the question, have we considered it, whether it was a damages case or a valuation case? Because, again, we know the questions coming. For people on this webinar who testify, everybody probably goes through the same process all of us do. We do our report, we know our report is right, and we sit there and then we spend about a day and a half trying to figure out, how would I beat me up if I had to beat me up? And we come up with 1,000 questions that never get asked in direct across, but we're prepared for it. And that's kind of what you have to do here. You know, you don't want to be in a position, did you consider this? And then have someone say, why not? And the answer is, counsel told me not to, or I didn't think it was relevant. When most of these cases are in basically, these judges are courts of equity, and they're going to ask the question only because they want to. It may not influence their opinion because there's case law and statutory law, but credibility is what you have. You want to look credible.
Michael,
Well, and at the end of the day, we have to remember our role is not to give a number for the client. It's to help that person, the judge, the jury, making the decision. And if it's going to impact them, they can make the decision. We probably should be giving them whatever information that we can quantify.
Right.
But it's
I-
also important that if you have like, I'm sorry, Michael, I'll let you go in a second. If you had a 12/31 date, for example, and the subsequent event does come into play after the fact, not at December 31st, you have to be very careful that disclosure does not taint the quality of the answer that you have that makes your report not credible for the December 31 answer. And you have to really make sure that you don't, if it wasn't known or foreseeable, that somehow or another you believe that at December 31st, that number would somehow not be correct. Because it may very well be correct, and it would be only if you change the date that there would be an impact. Michael?
My preference is to err on the side of disclosing more rather than disclosing less. And if there is a subsequent event that could be relevant to someone who is involved in the equation relating to the valuation, relating to the damages study, we disclose it.
Mhm.
You're never going to get slammed for disclosing it, but you can get slammed for failing to disclose something that was relevant to one of the major players.
Well, I think we've all seen this. We've seen people write reports that are 300 pages, and we look at them and say, you didn't need 300 pages to say what you said. And that gives somebody a lot of opportunity to attack you. But Michael's right. The obvious you can't leave out of a report, and this is an obvious that you should put in. It doesn't need to be War and Peace, but you should put it in there.
Michael, how would you deal with it if it was an oral report? You're one of the major advocates of no reports. So how would you deal with it?
Keep in mind, when you talk about being an advocate of no report, I have a fully documented file. All the work has been done. I've developed all my numbers. I've got all my supporting data. I've done my research. I've applied professional judgment and all of that. The only thing that I don't do only in a venue where it's not required is have a written document, that written vehicle that communicates my opinions. But when I don't have that, opposing counsel is going to take my deposition, and he or she can ask me whatever they want to ask me, and I will answer truthfully. I will answer honestly. When I get to the courtroom, when I'm on the witness stand, and I'm on the stand, I will answer every question truthfully and express my professional judgment and my opinions. And if there's something that needs to be disclosed, it's going to get disclosed. I am not going to attempt to hide anything.
Right.
No, but are you going to offer is my question.
If it's relevant, I'll tell you. If I'm on the witness stand today or tomorrow or next month or a year from now, and I'm doing a damages study that relates to damages that were suffered during this COVID-19 period, you better believe I'm going to make reference to COVID-19.
Right.
I'm going to be in front of it. I'm going to deal with that issue up front, because if I'm not, and opposing counsel brings it up, then I'm going to be totally embarrassed, and nothing I had to say is going to be embraced by the trier of fact.
Yeah, and Michael, in California, because I've testified in California several times to that issue, which blew my mind, to use a better phrase, but that's it. When I had to do that at first, you give me your entire work paper file in Excel and electronically, and what I found is usually the attorney on the other side is pretty well versed in what's in a valuation report because it's in their briefs. So the judge have seen it, and I've noticed that the judges out there, even if there's no report, they know the questions to ask when you're out there, which is very interesting. I was talking about cap rates, and then the judge was talking about, well, how come you didn't weighted average cost of capital? And I'm thinking, this judge has just heard this somewhere and is just asking me a question. Judge knew what it was. And
we train our judges well.
So even though it's an oral report, you have as much scrutiny and as much cross-examination fire than you can imagine. They're well, in various jurisdictions around the country, they're very well prepared for that. And if they get you to deposition and you have a hiccup or this and that, by the time you get to trial, you better know it's coming again because they've done their homework.
And you have time to fix it.
Yeah, but it's an interest. Listen, for us, I'm in the Northeast, and people, east of the Mississippi, it's not a normal thing. The further west you go, you see various courts that have it. It's a very interesting format. You have to be more in your game because you can't refer to a paging report for what you meant. You have to actually say what you meant.
Mm-hmm.
Okay, next question. I have a valuation I'm doing for a divorce case. The valuation date will be the court hearing date, which has yet to be set. Wouldn't any calculation of the impact of COVID be speculative and thus tossed out on those grounds? Is there any way to calculate the impact that isn't speculative?
Well, I think the great thing about that scenario is the valuation date has not been set. I'm guessing the hearing date has been set and it's within, 6 or 8 weeks from now, possibly based on the question. But I think when you're thinking about what's going on in that situation, what you can consider, how is the impact, how do you calculate that? You actually have known activity going on right now. So you can at least short term say, we know cash flow is impacted. It's either reduced quite a bit, but it's still positive, so we can account for that. Or it's been, reduced so much that it's negative and we have a cash outflow instead of a cash inflow. But with that, you're going to have to consider what measures has the business put in place to help the business. And I think this goes to your risk issue. If the business is not so inclined to help themselves, that just to me tells me it's a riskier business anyway. If it's a divorce and you have this, I saw this other question and I wanted to talk about, I'll kind of put them two together. If you have this emotional issue in divorce, a lot of times you have businesses where, you're the chief cook and bottle washer as the business owner, and then you're getting a divorce and you have like no motivation to continue on. And business acumen would say that business owner is going to, at some point, step up, brush his pants off or her pants off and continue on. I think the same theory or thought behind that approach that we've been taking for decades in divorce cases can be applied to COVID. So at some point, the business owner is either going to just give up and maybe start a new venture, or they're going to come back, sell it, or they're going to get a W-2. So we can think of all the different scenarios. But if they have a history of being in business, they're probably going to try to stay in business. But in the short term, whoever asked that question, it's a great scenario because you've got a situation where you can see what the business owner is doing right now that will tell you how you could probably predict what will happen with the business moving forward.
One thing I would offer in addition to what Lori is sharing is because I'm in a very similar case, in a divorce case that's hotly contested, and we had a December 31st, 2019 date initially. And what I did was I started talking with counsel, and then they were talking with opposing counsel, and then talking with the trier of fact. In this case, it's an arbitration panel. And I just began to share with them all the uncertainty that's there and all the guesswork and all the speculation that would be mandated to value the company today, and that this needed to be pushed out some, give us an opportunity to see how the businesses are going to turn around in the U.S. market, in this industry, get more valid information. And so they actually made the decision to push it out, into the summer. And so that might be something that you might want to consider pursuing with your legal counsel.
I like being really hands-on in the divorces if I can be. If you have the opportunity to do, like if you're in an equitable distribution state and you actually can do a model for proposed equitable distribution, or alimony or child support, and kind of know everything and take into account all of those things, because the judge is definitely going to be taking those things into account to try to come up with an equitable solution. I think that benefits you. I think I like the idea of moving dates if you can. I know, like in Virginia, the date of the trial is typically the date of valuation. In West Virginia, the date of separation would be the valuation date, but you can move it if there's a later date that's more equitable to place as the appropriate valuation date. But I think that's a very good question, but paying attention to data before and after is very important. And just talking to your freaking business owner, looking at like what they're doing, how they're doing, what they intend on doing, how much are they working more or less, and how does that make them feel? I mean, little things like that, it may sound stupid, but it's really insightful, and you can really gain a lot of insight from it. And help lead you in the right direction. And I think above all, too, before I forget, we have to keep in mind here that we're here to educate the jury. We're not held to this standard of perfection. So no matter what your approach is, try to make a logical approach, apply your assumptions based on facts and data. But if you got to provide ranges or whatever, two numbers, I do that all the time. And if you need to do that, that's fine. Just be very specific and provide it so that you can be helpful to the judge, because it's going to be their call as to ultimately even how much the COVID impact is or isn't relevant. So you just got to put it all out there like a teacher. You know, teachers don't come up there defending, you know, the algebra or whatever they're teaching. Okay, you go up there and you lay out the facts as best you can, and how, you know, what information is helpful to help the judge and or jury interpret those facts and data, and then go from there. And it makes your job a lot easier, especially when you walk in a courtroom like a professor as opposed to a hired gun.
You know, Brian, we went over this in depth a lot in the last two webinars. You might want to refer that question or to, you know, getting a recording from the thing, because we went into a lot of discussion about
Sure.
cases and.
Sure. On the NACVA.com/COVID-19 are the recordings of the two prior panel discussions that we've had with this group. You can view those recordings at any time. We are not issuing CPE for those recordings, but they are available, to Greg's point. Michael, you wanted to add something, I think.
I wanted to add just one thing, and that is our role when we're involved in a litigation, be it a family law matter or a commercial litigation, lost profits or whatever. Our role is to provide numbers and provide information that will help counsel get the case settled, get the case resolved. Sometimes we have to go into the courtroom to get it resolved. And sometimes taking the focus off of the strict, you know, the strict requirement of known or knowable, or the strict requirement of when something has to be disclosed or when it doesn't have to be disclosed, will get us closer to being able to provide useful information to the attorneys. The attorneys need to know both sides of it. They need to know the ups and the downs. And our role is to help get these cases resolved.
Mm-hmm.
Next
And,
question. Oh, go ahead, Michael. Sorry.
and we shouldn't lose sight of it. I'm going to shut up.
Well, that's good.
Hope I didn't cut you off. Was there something more you wanted to add, Michael?
No, that's okay. We'll save it for later.
Are you sure?
Yeah.
No time like the present.
We'll save it for later.
Okay. Next question. I'm involved in a litigation with an agreement between the parties to have a valuation done, and then one party has the right to buy the other party out. The valuation date is June 30th, 2019, and report was dated end of March 2020 at the very beginning of the shutdown, with no idea that the shutdown would continue through end of April. The report does not contain anything involving COVID-19. Should it be amended to include it? Also, do we know what kind of discounts would be applied to a small family-owned pizza shop?
One with
So
no
it sounds
cash,
like
right?
yes, include it.
Right.
Or a discussion of it. I'll let you guys give that.
There's a lot of variables there that I think we can go over for an hour. You know, small pizzeria. Is everything on the books? Is there stuff not on the books? We got a June 19 date, even if the report was issued in March. If that's the date set by the court, you know, we're talking evaluation versus the damages. It might be a little tough to go all the way back then for COVID. You could put the subsequent event and says, here's the value at June. It may be materially different today. What's the purpose? You know, they're trying to settle it, whatever. But there's a lot of other questions I think we would need the answers to really answer that properly.
Well, but I would just say, and we talked about it, this concept a little bit, but we didn't really flesh it out quite as much in one of our prior recordings. But back to that discount thing, So if you're standing in June 2019 and you're coming up with the value because somebody's going to buy the other person out, you have known, everything that you know about the business, all that going there. What you could do is say, well, it didn't account for COVID. Maybe maybe a way of handling an update would be, we know this was issued in March, so let's update it now. We now know when the social distancing might be released in certain areas of the U.S. I know, like in Atlanta, restaurants are open now, and so you can also capture, because I don't know where this pizza shop is, but you can also capture what did happen in the 5, 6, 8 weeks that they were closed down. Were they doing delivery and curbside pickups, and how did that augment the cash flow? So you could probably quantify. That was the number back in 2019. We have this blip on the radar, and we have some costs to get the company back up, the shop open again, new employees trained, et cetera. So you could probably quantify the costs to get them back working, the cost to be working at maybe, 75% or whatever, depending on how many seats that they had inside the shop themselves. And you could say, reasonably speaking, we didn't know about this in 2019 in June, but as we stand here today, we can quantify in a dollar amount some adjustment. Now, whether you convert that to a percentage and call it a discount, that's up to you, but at least you're going back and doing what both Hubert and Michael and I have been saying is, we're trying to provide whoever's making the decision with numbers so that they can make the decision, not us just saying, oh, that's not the value, it's something different, right? But you have mechanisms that you can look to do that.
But I think it's also important for us to remember that we don't create the date, right? We can only give information about that date. So if this was a divorce case back in June of 19 or whatever that date was, then I think that you need to you could put a subsequent event in, but I think that there's nothing from COVID that would possibly impact that value of that particular pizza company on that date. Now, that doesn't mean that it doesn't make sense today to change that date for the entire marital estate.
Right.
If that was to happen, then you have to value all of those assets in the marital estate with the COVID effect and move the date to March. But you can't just take the company and take that one asset out of the marital estate and imply that number is going to be different and not apply that across the board to all the other assets.
Well, this
At a
question,
minimum, I would put counsel on notice that there is an impact of COVID-19 on the business and on the other assets. Just have that documented in your file.
well, in a real business transaction, which I understood the question correctly, he was talking about a real transaction. The contract is being worked out. It's not been signed and executed and it's over yet. And the terms of the contract are critical to these things. They always address material adverse change. Sometimes there are earn-out provisions. Hubert, you've talked a lot about, we think there's going to be a lot of litigation about earn-outs. Advising counsel about these issues, as Michael said, I think is really important, because if the deal closes and these things aren't considered, there's a very high likelihood of subsequent litigation.
Right.
And you could help them avoid that.
Right. And we have to be aware there's a difference between the contemplated sale of a business in a matrimonial case and all the passive assets moving forward, and whatever value they are today, we split. But that's the value of those assets. You can take them. If there's a business that was worth $500,000 that's now worth, $100,000 because of COVID-19, everything that went on, the business owner is going to retain that business, the value to holder. So they're going to possibly recover that on the tail end of this thing. So that's why there may be an inequity to award the updated value to that individual, because that's like somebody getting out on the cheap.
Right.
So
Well,
those are the things the courts will have to weigh out.
Right.
It can go either way.
Yes.
Yeah,
Right.
okay.
Well, if in fact you were going to receive X number of dollars from that company and that became part of the support issues,
Right.
or all those other things that are part of that marital estate, those are big issues. And maybe you have to then reclassify some of that support agreements or child support or whatever. That's going to be based on the lack of revenue that's going to be coming in the future.
Right. Yeah, because all these settled cases, they use the word global settlement, which means everything accounted for. And if one variable changes, we have to go retool everything else.
Everything.
Yeah, you got to revisit the dates. So if the date's a movable date, that's very, very important. So like if you cash out your retirement to keep your business afloat, that's going to be important. So pay attention to all the other ramifications, no matter what you do. Make sure you pay attention to all of the other ramifications, whether it's a divorce or if it's a contract issue.
Right.
They may be able to move the valuation date, but it could just
Right.
be the fact that they did the valuation as of that date.
Yeah,
for no
I
reason
think
whatsoever.
I think it's 75-25 nationally of the states. About 75% of states are hard and fixed on their date. And
Right.
there's about 25% of the states which allow the fluid stuff. I mean, you're down there in West Virginia. Greg, you said something in Carolina about that. And I know Connecticut has it and a few other states. But most of the other states are like, here's the statutory law or here's the case law, and this is what we're sticking to. So in those ones, you know, you got to educate the attorney and the client that, yeah, I know you want to stick to a hard, fast date, but, you know, to be fair and to be fair to the trier of fact, you know, we're going to give this consideration and I'm going to answer it. And if you don't want me to answer it honestly, you can pay my bill and hire somebody else, which, you know, people have done that. There's people on this webinar who've done that to clients. Or you just be prepared that we're going to answer the question honestly and leave it to the trier of fact, because more often than not, they will do the right thing. Or you're going to settle this case on a number that everybody's going to be a little bit unhappy with, but not waste a lot of money.
But I think the trier of fact is the guy that's going to ultimately make that decision, not us, right?
Right.
So
Exactly.
ultimately, it's a matter of giving them the information that they need. And for those that are out there listening and they have valuations in process, go back to the original purpose. The purpose is going to give you a lot of information. It's going to give you the standard of value. It's going to give you the date. It's going to give you a lot of things that you need to deal with. And then you can have those conversations with the appropriate people to see if, in fact, a change of date is necessary or maybe even most important.
On the topic we brought up during this question, where it was the issue of earnouts, we have a question here. The question is, or the statement, recently this person had a conversation with a couple of attorneys regarding earnouts. Their thoughts were, as asset valuation uncertainty increases, earnout structures are the quintessential deferred consideration mechanic used during bridge valuation uncertainty. What are your thoughts?
Depends which side you're on. If you're the seller, you know, you're going to want an earn-out provision that you believe is attainable with all the risks. If you're the purchaser, you know, and you want to dictate the terms, that's where the litigation is going to come in, is on these earn-out. Yes, there's going to be a lot more scrutinizing of the terms and what material adverse conditions might exist after the deal. It's going to be an interesting. There's no one answer, but I see earnouts from a purchaser side becoming more and more a primary piece of deals going forward.
Yeah, and I see it from both viewpoints. I mean, you can put it to a point where the earnout makes no sense for the actual transaction to take place, and you cripple the operations. It's already crippled by the effect of the virus, and now you're going to add into it some additional earnout capabilities or liabilities that they just can't fund. You might completely terminate the golden goose that lays the egg, right?
Mm-hmm.
So you have to make sure that that's not, you know, that's laid out accordingly, and it's now adjusted so that the company has a viable future. And I think that's in everybody's best interest.
I think what was key about that, though, was something that I know that we're all thinking of is it might have to be much more of an earnout than either the buyer or the seller is kind of comfortable with, because right now just getting the money from any other source isn't a possibility. I mean, the banking system is just overloaded with, you know, bailout money and you know, the PPP and everything going on. So you may have these heavier concentrations of focus on the negotiations on
Right.
specifically the earnout provisions, and whether or not the seller is going to stay on, provide services, how that's structured, if it's structured in the form of salaries or something like that. You know, that's all part of, you know, what makes sense with the specific deal. But I think there's going to be a whole lot more of those, just because there's no way to get cash any other way to pay out the business.
And the big thing right now, like I was talking earlier about the Delaware courts, they're getting bombarded right now with deals that were in the works, because not only the material adverse condition in the contract between the buyer and the seller, if these deals rely on bank financing and leverage, there's additional clauses in those lending agreements where even if the parties still want to do the deal and the bank says, no, we're not lending you the money, that's another thing that can kill the deal right now is the lack of liquidity and capital. So there you're going to see some litigation and things happening. So these material adverse clauses aren't just between the buyer and seller, it's also from the funding mechanism. That funding mechanism could be a commercial bank. It could also be a private equity or some other non-conventional financing where they have their own terms and conditions that may be restrictive and kill the deal and maybe not allow the earn out, and they just want to walk away from the deal. So you're going to see litigation on that, but it's kind of a domino effect that happens with this.
You guys seeing a lot of deals put on hold for 6 months just to wait and see what happens and take away some of that risk profile?
Well, here's an interesting stat that I looked up today, and this is other than U.S. where a lot of these deals they're putting these material adverse effect clauses coming into play. There's a deal publication out there. Latin American deals plummet 50% in the first quarter of 2020. $8.7 billion worth of deal put on hold or canceled in the last month and a half. Now, when we talked earlier about 1980s and 1990s and not a lot of people were doing anything in the Caribbean and South and Central America and Latin America, it is a hotspot for development and manufacturing and innovation today. And deals are just being shut down because of this, because nobody knows what's going on. But that's, a 50% cut in the deal rate that they thought, and $8.7 billion today, which is only going to increase. And there's going to be a lot of litigation because there was a lot of American companies looking to infuse capital and do deals down there.
Yeah, the deals that I have, I've got 2 cases right now in the M&A space that are continuing to move forward, but it's because in both situations, it is 2 partners that own the business and they're selling to 2 key employees, or one key employee in one case. So they're actually, the both parties are very, very knowledgeable about what's going on with the business. And in both instances, the exiting partners and shareholders want to stay on because it's really kind of an exit planning transition for them. So they're going to continue to work on with both of the businesses. They're professional services, a pharmacy and an engineering company. But those kind of cases, I think, aren't necessarily just being abandoned. I think parties want to still make it work and they're more comfortable with making it work. But this goes back to whoever asked the question. There's definitely a lot of talk about what the earnout is and how that's going to be structured, and we're completely changing those conversations.
Right.
Again,
like Mark said earlier, there's going to be a lot more negotiating going on.
Right.
Yeah.
But that was a pharmacy.
Mm-hmm.
Think of that in the supply demand issue, what's happening here, right? The fact that it is a pharmacy makes all the world of difference because people need their medication regardless, maybe even more so than ever.
Mm-hmm.
It's a compounding pharmacy too, so they've got a lot of other things going on with them.
Yeah. Next question, or we'll move on. Assume the defendant caused the plaintiff harm 12/31/2018 and caused reduced sales. Assume that a key man died 12/31/2019 and that further reduced sales. Assume I'm hired post-COVID to calculate lost profits at December 31st, 2018, and COVID further reduced sales. If I take into account death of key man and or COVID in my lost profits determination, taking lowest current levels of sales, have I not given the defendant a windfall? Do I need to repeat that, or did you follow it?
No, I have it up on the screen and I'm reading it, and there's a lot of moving parts to this. Obviously you have a breach in the 18, which reduced sales. Okay. Then the key man dying. Well, that's not a breaching action. You can't stop someone from dying. And then you have the COVID hit. I mean, there's going to be a lot of professional judgment employed by whoever has that case. And, is it a windfall or not? You're going to have to make that determination. We talked earlier about the COVID hammer or sledgehammer. You're going to have to make that determination in this case. But the key man one, I don't think you could ignore if that key person drove a lot of sales and is not the plaintiff in this case. That's something you're going to have to tie into your causation, because that's not a but-for action.
You got to be careful not to combine lost damages in certain cases, because you're going to have a amount of the loss that would be accountable to something, but not all losses are added together. You know, so if there's a 10% loss in total for a particular year, maybe in revenue, some of that may be attributable to COVID or what have you, but some of that may be attributable to the loss of the key person. So you got to be careful.
Right, but we're talking about a discounted cash flow model. So if the 2018 breach, you know, they factor that out in the cash flow, what the sales would have been. Then you have the death of the key person. Now, is that dip in sales permanent or temporary? If it's temporary, well, you're going to have a short-term blip, and you're going to carry it out to the long term, where if that person can be replaced and those sales can be retained, your model is going to go up in the out years. And the COVID issue, again, is it going to be temporary or permanent? So you're going to have to consider all those variables when you do your model. And if when you're done with your model, you don't feel like the defendant's getting a windfall, then you did your job. I mean, it's a gut check every time when you do your work.
Yeah.
Well, and I think also, though, you have to consider, are you managing it in, so 2018, you know, all of 2019 sounds like, you know, that's something that you can identify, but are you going to manage the death of the key person? You know, was it sudden? Was it known or knowable? You know, what was going on with that person? And like Hubert said, you know, could they be replaced? Could they be replaced in 6 months? But another, you know, thought that I had when you were talking about that, Hubert, was what if you just put the risk of the key man into your discount rate?
Right. And
the
flip side,
the model the same. You leave the model there. You just put the risk of the key man in there. Now that doesn't address COVID.
right? But the flip side is don't do both.
Right. Yes. Yes.
Right. That's where we're trying to help people here, I think, is we kind of understand what we're going to do and how we're going to look at it, but I think our concern is that don't do both. If you put a lot of weight on the key man and you put it into the discount rate, then don't go crazy reducing all the sales into perpetuity or into whatever, how many years your model goes out, because that would be a double dip. And yes, that would be a windfall to the defendant.
Hubert, don't we have an issue with foreseeability with this, that, you know, if we don't put it in the discount, take an event that happened after the 2018 date, you know, there's no way you could know you were going to lose the key man. But if you put it in the discount rate, you've got a company in 2018 that's already dependent upon a key person. That does increase risk. Then you don't have to deal with any kind of a challenge about foreseeability.
Correct.
That's what I was saying, is that, you know, if you put that in that discount rate, then that kind of relieves some of the pressure on those lost earnings or the damage.
I've just seen where a lot of times people try to account for every negative event as something in their report, as to say, well, some of this can be captured in a discount rate. Some of this can be captured in the cash flows because it's not permanent. But whatever way you're going to do it, be prepared to stand behind it and don't make the mistake of double dipping.
Right.
You know, one way I help with that and identify it even in my report, I'll list out all those risk factors and I'll actually check off on where that is accounted for, whether it be in a discount or whether it be in my benefit stream, so that you're actually telling them where that's being taken care of so you don't double dip it.
And then trying to figure out how you're going to handle something, always keep in mind that I'm going to have to explain it to somebody else. So sometimes the simpler way is the easier way to do it. It just depends. And sometimes that can help lead you in the right direction, so long as the way that you handle the adjustment is appropriate.
Right.
You may have maybe 2 options, 3 options or more. Take a look at how easy it's going to be to explain, or how easy and transparent the adjustments or the reflection in your discounts are going to be seen.
And if you're going to adjust the discount rate, be prepared to answer questions on why you did it. If you adjust the discount rate by 2 points for the person who died, and that person accounted for 20% of the sales of the company, right? And you say, well, you're going to get it on stand. Were you aware that Mr. X died and he was responsible for 20% of sales? Yes, it's factored into my discount rate. Well, do you know how much in sales? Do you know what this person's role was? Know all those answers, because they're coming. So when we do adjust the discount rate for those specific events, be prepared to answer them. Don't just say, I did it because they were a key man who died, and leave it at that.
Let's switch.
Another issue on this risk is, because I'm looking at a follow-up question, I think, from the person who asked the question. Let's say that we assess an increased risk because we have a key man in the sales position, and then we replace him, but we still have a key man. Let's say that that's our own maybe major salesperson. So going forward, we still have that same risk.
Mm-hmm.
So keeping it out of the income stream and just
Right.
dealing with it in the discount rate would
Absolutely.
Let's switch gears a little bit. What about evidentiary issues? In building our damages models with our projections of the future having so much uncertainty, how will damages calculations meet the threshold required to be admissible in court? Michael?
That's something that we have to consider on every case that is going into trial. We're at a point now. At this point in time, we have to look at. I want to say this without getting into trouble. We have to look at more things. We have to be more careful when we look at the variables that enter into our damages measurement calculations. Because there are so many things that are uncertain, and we don't have the same benefit of historical data that we did during times that were somewhat more stable. The important things in terms of evidentiary issues is we don't want to do anything that's speculative. We want to do enough work that it takes us out of that world. And number two, we want to be careful and use the best information that's available.
Right.
We want to, I'm going to get on the phone and call 1-800-MARK-CUSIC or 1-800-Laurie Maston and make sure that I'm using the best stuff that's available.
Right.
And I'm going to stick with traditional damages measurement methodology. I'm going to challenge every one of my assumptions. And as we discussed earlier, just get ahead of every point that I would expect opposing counsel will address when I'm on the witness stand.
Michael, from an evidence perspective, don't you think it's more important now than before to really work with counsel on discovery requests?
Absolutely. It was always important, but there were times that counsel didn't follow through the way we would want him or want her to follow through, but now it becomes critical.
And in those events that they don't get you early on in the discovery request, tell them next time you want to retain me in a case, get me early enough so that I can help you, so I can help identify the discovery requests that are going to be more pertinent.
Right.
And that way we can get this stuff done on the front end as opposed to trying to force it or not be able to get more discovery on the back end.
Yeah.
But I think there's something here that's beyond just discoverability issues. I mean, it's sufficient relevant data to have an opinion as to how is COVID going to impact my analysis. And the good news there is we're all on the same, boat, so to speak, right? No matter if you're on the plaintiff side or the defense side, we're all just trying to grapple with guessing in some ways. But that goes back to why I put those few slides together that we looked at the beginning of today's time together, is we do have some evidence of what can or what could or how long things might happen or last. How long this is going to last, because it's different, that's professional judgment, and we can't answer that question.
Right.
But as time moves forward, we're going to be able to do it. But I think for the Daubert challenge issue is, as long as you are reasonable with what your inputs are, that you've researched it and done what a typical person in your position with your level of knowledge would look at, consider, and include, then I think we're doing our job, because the people on the other side don't know.
Right. Well, look at this. It's a best evidence rule, right? That's what we have to deal with. Now, let's take this practice hypothetical. Plaintiff expert basically says the cash flow model is going to increase at 5% for the next 6 years and then drop to 3%. Defendant's cash flow expert is going to say, no, the company is going to grow at 1% for the next 7 years, right? It could be that defendant's expert is wrong 2 years out and plaintiff's expert is right. And 2 years out, it could be plaintiff's expert is wrong and defendant. So again, be able to stand behind it. But what we say today for everybody on this call could be the total opposite 2 years from now, because as Laurie was alluding to, when you look at that chart, we don't know what the heck is going to happen on the other side.
And I think I agree with Laurie, what she said, 100% about we have to get sufficient data to form as a basis for our opinions. But I'm thinking about cases where we are retained by counsel who is not the business owning person, and we're trying to get information about the business, and that, of course, they don't want to give it to you. They don't want to release certain information that might hurt them, and it's important for us to help the attorneys understand what it is we need, particularly in this environment with the COVID-19 issues.
Don't you really have to address a lot of your assumptions and limiting conditions here as well to get that reasonable test down? I mean, if you're going to put together some type of projections, there's going to be some hypotheticals that you're going to have to put in, whether it be growth or extension or time. And there has to be some reasonable amount of work behind those estimates, right?
Mm-hmm.
You can't just say because Mark Cusick thinks it's 6 months that that's what it is. And that's where Larry comes back trying to dig up some information that kind of helps your case to say, how long is it reasonable to understand that this could happen? And then back up what the economic is happening. The experts are saying in the economy, how the world, is adjusting. What are some of the timelines in other countries that have pulled out of this? And they've been ahead of the United States. So what does that look like going forward? And how does that then affect my projections? There's a lot of data you need to go through to build up those assumptions. It's not just because I get up one day and say, well, Mark Cusick thinks it's 3%, so let's go with it, right?
But when
So hold on, Greg, did you say that you weren't getting information
From the client?
from the client? Because that's a scope limitation. It's a
Yeah.
whole different issue we have to deal with. If
Right.
our own
Are
client,
you asking
listen,
me, Hubert?
yeah, I'm asking you because if our client is not giving us information we need, that's the beginning that we have problems with our client. If the other side isn't giving us information, well, that's part of the fight. And at some point, the trier of fact's going to say, well, make whatever negative inference you have to, just make sure it's reasonable.
No, I was referring to the other side.
Okay. Yeah, that's unfortunately a common problem, especially if it's not going to help their position.
Right.
I
Right.
think it's worthwhile
Just-
to point out that in all of this discussion, when we're talking about what this future might look like, we need to be real sensitive, just like we had to be in 2010, 11, 12, that whatever we're modeling in there, that we're not calling that growth. Because
Exactly.
we're going to have a recovery period.
Right.
And don't confuse, I'm using a 2% GDP assumption or a negative GDP to do growth. You can't do that.
Can't.
All right.
We
I
got about
had it on a particular audit from the Internal Revenue Service, and the gift was done in 2008 when we were at our lowest mark. And they came back and took a look at this and said, okay, well, we're now back in 12, and they did that 08 to what was 12, and they called that growth and extended it all the way out and put a terminal value in and said, now you owe us millions of dollars based on all this. And the reality was, and you have to understand that was all recovery, and we didn't even surpass the 06 numbers, much less any type of growth. So really understand what those numbers are telling you.
Yep.
We got about 20 minutes left and some really good questions. This one dealing with Daubert challenges. Will you see a huge increase in Daubert challenges in this new environment? First question. And second, how do we proactively protect ourselves from Daubert challenges?
Well, answer to the first question is yes. And two is continue to do what you've always done. It's rare for financial experts to be excluded on a Daubert challenge if we use peer-reviewed, accepted methodology, which we all do, or we can get training at the NACVA for. But if people are going to go off wildcarding and come up with wildly speculative things that they're doing in rates and things like that without being able to justify it, you're going to see challenges there.
Yeah, I agree.
I would deal with conflicting assumptions too on
Mhm.
the front end. A lot of times people will use an assumption that something else factual conflicts with, the actual revenue didn't do this, and you use the assumption based upon some study.
Yeah,
Pay attention to those things because those things can get popped up in Daubert challenges,
right.
and focus on pretty much like I think a number of us have said today, focus on every single aspect of your calculation.
Right.
Every single, down to every rate, every component, every methodology, everything. And be
Right.
able to
Right.
defend it and defend why you didn't do something else or why you did what you did. That goes down to the heart of it, really.
Well, what's going to happen there from a practice point is you're going to be challenged on certain things. More often than not, the judge is going to let you in. And what the judge is going to tell the other side, the methodologies are similar. You might disagree with some of the assumptions. He goes, that's what cross-examination's for. And that's usually what they say.
Michael, you had a comment.
Okay,
Yeah,
Mike.
my comment was use reasonable assumptions, challenge all of the assumptions, use the best evidence available, make sure that you have the full world of evidence and have considered it appropriately, use mainstream methodology, and be careful.
Right. That's
Oh,
great
yeah.
advice. Well, I'll put everybody on the spot. How many
Agree.
people have been challenged for a Daubert challenge? How many people have been excluded for a Daubert challenge? And have you gotten back into the courtroom, Michael?
Yes,
Exactly.
that didn't affect anything.
Exactly. I mean, they have all these trackers and everything like
Right.
that, and people weren't. Every case is different. Every courtroom is different. And, you know, when you look at why some people were excluded, you kind of say, really? When you look at the facts and circumstances, why they kick somebody out, it's not the end of your career.
Well, and oftentimes it's a legal issue that suddenly
Right.
whatever you've done is no longer meaningful to the trier of fact because they made a ruling that excluded that portion of the case.
You relied on a fact witness
Mhm.
doing a report, and a fact witness was excluded. Goodbye.
Right, right.
When I've been challenged recently, it's been really focused on sufficient relevant data. Arguments that I didn't consider, something in the economy or something in the local business sector or things of that nature, and you just really have to be thorough.
And where in the code of conduct is there a definition of sufficient relevant data?
It's
You're not going
professional.
to find it. It's professional judgment.
It's what the guy on the other side of the case didn't do.
Yeah.
Exactly.
Here's a good question as well. Many of the legal jurisdictions are adopting or exploring virtual venues for depositions, arbitrations, hearings, and perhaps trial. How does this impact our work in the financial forensics arena? Michael?
I remember about 15 years ago, maybe 20 years ago, I was an expert in a case, and my deposition was taken via telephone. And we set up a speakerphone this was back in the days when we were hardwired for events like that, but we had a speakerphone set up in counsel's conference room, and there was a court reporter sitting there, and my retaining counsel was there, and opposing counsel examined me over the phone. And to tell you the truth, I had complete control of that deposition. You know, usually the attorney who's taking your deposition is the guy who has control, but because I was not there, because he wasn't looking me in the eye, it just changed the dynamic. I had another one. This was in the early 2000s. I was in my conference room with a speakerphone and a court reporter, and both attorneys were in Oklahoma, my retaining counsel and opposing counsel. And talk about control of the proceeding, control of that deposition. There's no way that they can gain the same control. So it will create a little bit of an imbalance in the dynamics between the deponent and deposing counsel in the depositions. Sometimes, well, you know, I was going to say that it may be wise to have local counsel there or have someone there. But the problem is with social distancing, we want to minimize the number of people are there. So it's going to be interesting. But, you know, certainly in the criminal trials, you're seeing, you know, there are hearings that are done electronically. There are going to be arbitrations, mediations. That's something we're going to have to get used to. And I submit that the biggest way it's going to impact us is once we learn how to use it and how to use it effectively, even when the social distancing requirements are eased, we're going to be so comfortable using that type of venue. And it's going to be so much more efficient that you're going to see more and more. Our habits are going to change.
Mm-hmm.
Yeah, and you pay attention more to like body language. Like here today, we're recording all of this right now. And if somebody takes your testimony virtually, they're recording it, I'm sure, if it's a deposition or what have you, and especially a deposition where it can be played back during trial. So, you know, you really got to pay more attention to body language in situations like that.
Mm-hmm.
You got to pay attention to more than just what you're saying, but how you say it and how confident you look when you say it.
Mhm.
The same way you would do in a video deposition. If you,
Exactly.
yeah, if you're in a video deposition, you have to be on your game as you would be in trial. In just
Right.
a deposition that's transcribed by the reporter,
Right.
it's somewhat more relaxed in terms of your demeanor.
Right. And the difference in a video dep versus what you're talking about, in a video dep, if you look at the screen, we're all seeing headshots now. A video dep is usually your full body on the screen, which they can see your hand gestures, your mannerisms, and the little things you do when people fidget, how you move around your legs. Where here, we're lucky, you just see the headshot and what's going on above.
Yeah, you can't look the court reporter in the eye when you're trying to say something really complicated, make it look like
Right.
you've done that.
Mm-hmm.
A related question, what additional documents would you seek in the current environment that might not be in a standard document request list?
Updated cash flow projections from the ones they gave you 3 months ago. Or if they don't have them and you were doing some sort of modeling based on the past, well, everybody's doing cash flow analysis now because they're trying to keep their business alive. So there's something out there. So those discussions need to happen. I know I didn't ask for it, because you said you didn't have them, but do you have something now? And if you don't, could you put something together? Because it's going to be relevant.
Yeah, supply chains as well.
Yes.
There are also professional organizations, consulting firms that are conducting surveys of CFOs and CEOs and trying to get their thoughts based on what they see going on with supply and demand in their business and in their industries as to when this thing is going to turn around, what their expectations are. Obviously, those are people's best guesses, but it's useful information.
Yep.
I would add documentation of any reconfiguration of your business operation, documentation, correspondence, outlines, communications relating to changes in the way your employees work. Are they working from home, working from the office? Documentation relating to layoffs, documentation relating to financing that you're seeking, documentation relating to the restructuring of your costs, communication with your landlord. That all becomes relevant.
Yep.
Next question, we got to this a little bit earlier, and Hubert, you suggested that we circle back to it. What is happening in M&A litigation?
It's ramping up. Pre-deals that are falling apart. There's a lot of cases that have come out there. Delaware is getting hit hard with a lot of new cases, but a lot of the other venues are, where usually these documents are ironclad when they go into the deals, but now people are trying to change the terms, and that's causing some litigation. I mean, right now, Bed Bath & Beyond, it was in a deal with 1-800-Flowers for a subsidiary of about $250 million. Well, 1-800-Flowers wanted that deal. Bed Bath & Beyond said no. They tried to use a material adverse clause and get out. And on the post-acquisition side, it's usually based on working capital and ratios, and with the impact of what's happened, you're going to see the ratios that have come into play in a lot of this post-acquisition stuff probably be non-favorable to the seller, and there's going to be litigation around that because, well, how much of that was caused, I sold you what I sold you, and even though it may be worth less today, we cut a deal on what I thought it was. So, unless there's a provision in the deal agreement for an adjustment to the payout, people are going to be upset about that. Now, there's going to be some litigation. People are going to fight over it. Those issues are usually negotiated, for somewhere down the road, but, they're not really going to renegotiate the purchase price. And if they do, then it's going to be really ugly litigation. But there's a lot of activity going on out there, and not just in public companies, but private companies. You have a lot of private companies that are involved in roll-ups, especially in healthcare, that are aligning with private equity firms and other funding sources, as well as, the family business where they grew it. The second generation doesn't want it. It's very profitable, successful. They're looking to cash out and maybe some sort of roll-up or sell it to someone else. And a lot has changed. I mean, the landscape has changed. Now, the long-term value may be there, but today, short-term cash flow issues and that, they might want to pay less or defer a payment. And, If you're the guy where the seller wants to have you defer a payment, you're like, whoa, I need the money too, so I need you to pay me. So there's going to be a lot of issues for practitioners to deal with, and a lot of consulting work, damages work, and valuation work.
Two really good questions just came in, and we've got 10 minutes left, so let's be aware of our time. The first question is, given the increased probability of bankruptcy for many businesses due to the economic crisis, should an appraiser assess the potential for insolvency? And if so, would you state it in the FMV going concern engagement?
Well, I think, I'll just jump in real quick and say, I think one of the things that we have discussed previously is maybe using a probability weighted model as far as what your forecast might look like, or a projection if you're including a hypothetical. Hypothetically, they survive. Hypothetically, they don't survive, and then weighting those in some way. I don't know that we've directly addressed whether that, how you would treat, bankruptcy versus just going away. But we kind of have thought about and talked about maybe using a probability weighted model and incorporating some of those concepts in there, but maybe not BK.
Right. Well, if we ask for updated projections and they indicate a cash flow crunch and maybe a going concern issue that a lot of auditors and people who do a test work might see, maybe that'll help us identify that, then we have to make an evaluation. Here's their 3 and 6 month plan. Based on what we know today, do we think that they're going to survive 3 to 6 months? That's going to be a judgment call on our part too. The task of using judgment and looking at data and making decisions never goes away. You cannot attend a webinar where you're going to get all the answers for what your professional judgment is going to have to be.
We also have some subsequent training being led specific to bankruptcy, insolvency, restructuring. 15-hour webinar series scheduled in May, where these issues will be provided in much more in-depth continuing education. Another quick question as we're wrapping out of time. Would you advise an expert to lay out a range of future damage amounts more so now than you would have before COVID?
I've always been an advocate for future damage ranges and damage cases. So I don't think I would do it any more now, but it's most certainly something, if you didn't do it before now, I would suggest you consider it. I think it goes along with the educating the trier of fact type of deal, and educating the parties, both the legal counsel, as to the range of possibilities, vulnerabilities, and all of that. So
I would do it for purposes of meeting with counsel and for purposes of advising and guiding counsel.
Right.
If I walk into the courtroom, I know I'm going to be asked the question, what is your opinion? I mean, what is your best opinion as to the amount of the damages? And I'm going to be prepared to give one number.
Right. I mean, just to go along, right. I agree that we should know the range, but I had a case recently where the opposing damages expert came in with their range with 13 different numbers in their range, ranging from 1.5 million to 13.5 million.
At least it was close.
And the attorney I'm working for at a big firm goes, this guy's, really, really credible, well-known in the tech space and all this. I said, well, then why can't he make a decision, was my question to the attorney. Because I said, that's where the vulnerability lies.
Well, you can simplify that too in a presentation. You can give a damage ceiling and a damage floor based on best case minus worst case mitigation or something like that.
But you can't testify to that.
No, and I think that you're not really giving guidance to the trier of fact if you give them a
Right.
window that's the size of a football field.
Yeah,
Well,
You're asking the trier of fact to do your work.
right.
Yeah, but if there's two reasonable alternatives to a damage presentation, I testify to that.
Yeah, but that comes back down to the actual facts and circumstances, right? And then they weigh the facts and circumstances that go to one direction versus the other. It's usually cut and dry one way or the other.
Yeah.
Well, how about the question, well, which one do you lean more towards? The lower one or the higher one? Why not?
Well,
which one. I mean, I think, and they teach these in NACVA trial prep classes too. One of the rules of being a testifying expert is never allow yourself to be put on the stand to answer a question for an hour that has nothing to do with your conclusion. And that's what's going to happen when you give these wild ranges.
Yeah, you
I
can't
think
go
you do run into trouble with that because a really good, sharp attorney will begin questioning you about all the assumptions under each one of yours. And at the end of the day, he's basically going to say something like, well, you really don't have a clue, do you? And then your opinion, it's like, what opinion do you have? So I think, just in respect to Zach, I think there's circumstances where it can work. But I think in the majority of cases I've been dealing with, I've been safer picking a number, as Michael said.
Oh, I agree with Zach. My point is the range can't be all the way out in the stratosphere from the top to the bottom end, because
Right.
or if you're going to have a top and bottom number, and these people actually put in 11 other situations in between the top and the bottom, and
Right.
that was like, well, they're going to have to testify to each and every one, and our attorney is going to pick them apart in each and every one. So if you have a floor and a ceiling, a lot easier to testify a floor and a ceiling because you're tweaking a couple of assumptions, and it's up to the trier of fact to pick which one. But don't
Right.
ask a trier of fact to pick the right assumptions out of 13.
Right.
Yeah, that's way too many. It has to
Mhm.
be simple. You can take
Yep.
the best case pre-damage minus the worst case
Right.
post-damage and do a ceiling, and the worst case pre-damage, best case post-damage
Yep.
event, and then give yourself a reasonable range that is simple, that everybody understands.
And what you're talking about, Zach, is what the client's and attorney's going to ask, what's my worst case, what's my best case? And you're going to give them that information,
Yeah.
and then you're prepared.
Yeah.
And a lot of times the judges split the baby anyway, so you might as well give it to them.
Well, we're close to time, and we'll repost the slides that we were using for this presentation. Just to confirm with everyone, there are no handouts or materials for this Q&A. The questions being posed are coming in through this chat, but also have come in through our survey. There's no actual handouts. This recording will be made available at the nacva.com/COVID-19. So you can go back and view it, or let your colleagues and others know that it's available, along with the prior webcasts that we did. We have one topic coming up on Wednesday this week, where we'll conclude this series. And we're also beginning to work with other faculty and instructors after this series concludes on Wednesday to schedule coaching and mentoring and one-on-one group kind of activities with case studies. So though we will conclude this series on Wednesday, we will not conclude it all round. There's more training coming. There were a question or two posed relating to business interruptions, lost profits. We have a webinar tomorrow, a free 2-hour webinar, which will dive into COVID-specific issues for business interruption claims and lost profit claims. It's a free webinar that starts tomorrow. We have an on-demand series, 15 hours on demand relating to lost profits, business interruptions, and other topics also scheduled through our public service campaign, Staying in Business. To wrap today, you all, any closing remarks to those folks who are working in litigation? Any last tips and tricks to navigate this kind of rocky terrain? Greg?
I'm going to steal from Laurie again, and just she made just an incredible comment that none of us are as smart by ourselves as all of us. And the biggest value that I get in doing my work really comes from these guys that are on this panel with me and others that I can pick up the phone or email and talk about a problem, how I'm trying to solve it, get their thoughts. I really encourage everyone to do more of that, particularly today, and take advantage of these upcoming sessions that Brian was just sharing, the coaching sessions, things of that nature. Just get to talking with others, find out how they're solving their problems. It'll be a huge benefit to you.
Mm-hmm. Michael?
I would mirror everything that Greg just said. All of us together can come up with much, much better, much more credible, much more defensible answers than any one of us on on his own or her own. I will tell you that on occasion, I have reached out to every one of the individuals on this panel with issues and matters that I'm involved in, bounced the question off of them, have gotten great answers. Often the answers gave rise to additional research. But one of the beauties of an organization like the NACVA is there's so many resources, so many people to reach out to, and professionals who are happy to hear from you, happy to share with you, and happy to put you in a position where you're going to do a lot better for your attorneys and your clients.
Zach?
Yeah, I would say reach out to anybody that you can. I'm always available. I've talked to everybody just about on this panel as well. I would also say focus on every aspect of your templates, and if you have downtime, work on everything. Do more research. Invest in your intellectual capital through CPE, and make the best use of your time. And then when you start to get busy, you're going to be ready, because it's going to get busy.
Laurie?
Yeah, so since I can't say
All
not
your
one of
awesome-
us is as smart as all of us, because Greg already said it for me.
Sorry.
Along those lines, like the camaraderie that we have in our profession, I think it, is great. So take advantage of that.
Mm-hmm.
And whether you're a member of NACVA or if you're an AICPA member, this is kind of a non-denominational conversation, right? This is about all of us put together. So I don't care, what your come from is, what organization or what credential you have, we're all here trying to solve some problems that we are all facing. And so I think my takeaway is that, consistent with my thought that all of us together are smarter, just keep up to date on what is changing. So if NACVA has a COVID page, keep up to date on that. AICPA has a fantastic, toolkit page for COVID, and it's, separated between business valuation, interruptions, taxes. I mean, they've got just tons of resources. So the resources can be overwhelming, just like the news stories. Focus in, just a suggestion, pick 3 resources that you really like and just touch them, every day or every other day, and make sure that you're up to speed with what they're changing.
Last few minutes, Mark and Hubert.
All right. Well, my advice is this. I use this once, take the polar bear plunge in life. Don't be the first and afraid to, don't put the toe in the cold water, jump in. Well, for this type of stuff, stick your head out of the tunnel. We all get involved in our practices. We do really, really good work. Stick your head out of the tunnel once in a while and call one of us or somebody else because the tunnel can be a dangerous place. When you start believing everything you say, you need to talk to somebody else and get another perspective.
Right. And Mark?
Yeah, just remember, guys, that the NACVA is really a family. It's a family to me, and I'm thinking it's a family to all of us. And don't be afraid to reach out because you're intimidated. Just remember, we all remember there was a day when we started day one, and that never has left us. And we'll take every call every time and help any way we can.
Yeah.
Yep.
Great. Thank you all. And for those of you viewing, please do visit often the nacva.com COVID-19 page. We are adding more content daily, and we'll soon be launching more courses and trainings for mentoring and coaching, both in valuation and litigation. Thank you for joining us. If you perchance missed a poll question, you can reach out to our headquarters administrators, letting them know that you might have missed a question. You will be able to log into your account on nacva.com in a few business days to access your CPE certificate. And we'll be back with this panel on Wednesday afternoon, speaking more specifically to industries and specialty areas. So if you're available to join us, please register, and we'll be back on Wednesday this week with the 4th in this series. Thank you again to our panelists for joining us. Everyone have a great week, and we'll be back here, same bat time, same bat channel, or all kinds of bat times and bat channels as we produce a ton of great content for you to strengthen your practice and these engagements. So thanks for joining us. We'll see you soon.
Thank you.
Thank you, everybody.
Have a great week.
Take care.
Thank you.